So also for these firms which have banks are in their panel, what will happen is when a new matter comes in, emails will be sent to all the advocates. And when the emails are sent to all the advocates, the question is simple. Do you have any conflict in this matter? Is there any conflict with this situation? Is there any conflict with this, any conflict that will arise in this situation? And then the advocates are to answer yes or no, and then so that they know how to proceed with the matter. But from the face of it, there's no illegality in acting for both parties. You can, it's allowed. But if a conflict will arise, you foresee a conflict arising, then it's prudent for an advocate to recuse or maybe refuse to take up the brief. So there is no problem whatsoever in this situation. Okay. So a conflict will, now just to sum it up, a conflict will also arise whereby Rudy and Clyde have been taken to court and the advocate who prepared this wants to appear as a witness for Rudy. No, there's conflict there. Okay, is that fine? Is that fine? Okay. Okay, now we were going to where are we? You've done the due diligence, everything is in order. You now start preparing the charge documents. Who prepares the charge instrument? Advocate for the charge. Yes, charge.
Yeah, it's the advocate for the charge who prepares the charge instrument. Yes, but Solonka, I have a question. Sorry for taking you back. Do you think we should interchange the second and the first step? I'm thinking that we should start with due diligence, then we go to preparation and sending of the offer letter. Because Solonka, if you look at the case of Carlisle versus Kabolik's mock ball, now that you're talking about an offer, once you make an offer, this is not an invitation to treat. Once you make an offer and these people accept it, then you are bounded by it, right? Yes. Now, imagine a situation where you're bounded by a contract with this person who you don't even know their credit worthiness. You don't even know the value of their land. You don't even know if this land is actually overcharged to the extent that you cannot even perform whatever is in the contract. So to that extent, now that this is an offer letter, and keeping in mind Carlisle versus Kabolik smoke ball, don't you think that first of all we need to do our due diligence so that we know what we are dealing with for us to send this offer? Because this is not an invitation to treat, which we can get out of. This is an offer. What do you think?
Okay, that's a very good observation. Okay, you can put it that way, but before the offer letter is sent, much due diligence is not done at that point. You'll come to see how it works, okay, practically. Yeah? So if you read the offer letter, I have some offer letters here, but I can't share them because of client confidentiality. I can't share the same because of client confidentiality, but there is usually a clause. There is a clause there. And that clause is to the effect that the entire transaction will only be valid dependent on the securities given, registration of these securities, valuation, and all those stuff. Yeah. So at the part of the bank, what will happen is what you've mentioned that actually which I left out, maybe valuation. Valuation, that's what will happen. Valuation, maybe to check. They will call for the documents on the face of it, look at it, but proper, how can I put it? Proper due diligence is usually done after the offer letter has been given. And it's usually done not even by the bank itself, by the advocates. So, you'll find, for instance, which firm X and X. Equity Bank has firm X and X on its profile. So once they receive, the offer letter has been written, everything has been done, what will happen is the bank will send the offer letter to the advocates. It will send the copies of the ID and all supporting documentation, including the title document, to the advocates to their advocates now, to the advocates, to the X and X advocates. Now, part of due diligence is to try and check. They'll start now. Look at the everything encompassing. There's actually a question on due diligence here. We'll go to it. Everything to do with due diligence, investigation of title. How do you investigate the title? They will do a search. After doing a search, I think for when it comes to charges, a search is enough. Look at, are there any encumbrances? Are there any problems with this title? They will look into the normal land report, all those issues, so as to try and do it and determine the validity or the Yeah, just how the title is. So it happens. That's what I'm saying. It happens both ways. It happens before the bank through its lawyers. The bank has its own lawyers. Will do it after. Then the other advocates will also do it. Advocates for the chargee. So yes. And if you can check some of the duties of the advocates for the chargee is due diligence is one crucial step. So we were in step I think 3 or 4. You see, you're mentioning it, just we're going briefly. So it's preparation of the charger by the advocates for the chargee. That's true. He got it correctly. The one who prepares the charge is the advocate for the chargee. Now let's just, because this is revision, who prepares the discharge?
Advocate for the
Advocate for them?
vendor.
For the vendor, yes?
Yes.
No, don't use vendor or purchaser. No, here we're using chargee and charger. So who prepares the discharge?
Oh, charger. Advocate for the charger.
Advocates for the charger. Okay, now let's go on to a sale agreement. Who prepares the sale agreement?
Advocate for the one
vendor or purchaser.
The vendor.
Who prepares the transfer instruments?
Transfer is prepared by the purchaser.
Okay. Who pays stamp duty?
The purchaser procures it from the vendor's advocate.
Yes?
Purchaser's advocate. The purchaser's advocate pays it, but he procures it from the vendor, the purchaser's advocate. I mean, the purchaser's advocate is the one who pays it, sorry.
Yes, it's the purchaser's advocates. Now, who pays for capital gains tax?
CG vendor.
Vendor.
Okay, yeah. So there are some of the concepts that you need to get to understand, yeah? So you've answered it correctly. So we start with preparation of the charge. Who prepares the charge? Advocates for the chargee. Yes?
Just a question. Because this land only has a sale agreement, shouldn't we also prepare the transfer? Because we can't charge the property if there is no transfer, since it will not have moved to the purchaser, so that it can then be charged.
Yeah, that's a good question. That's a good question. So yes, and it stems back to what we read there in under the PU and under condition 8 on completion documents. So what will happen in this circumstance is there is it simultaneous? Do you talk about simultaneous registration of the transfer and
I believe so.
Yes. So there is a simultaneous registration of the transfer and the charge in favor of the bank. So yeah, you could mention it, though practically speaking, that's what will happen. Transfers will be prepared because you're also acting for the purchaser. Yeah, you can mention it here. Well, now you see the question was focused on. Actually, you have to mention it because before the security lands to client bank, you have to prepare the transfer documents. But I wanted to restrict myself on the charge because the question is on the charge. But legally speaking, you are more than 100% correct on how to go about this transaction because you're acting for both the purchaser, yes? You're acting for both Rudy and you're acting for the bank. So you will prepare the transfer documents in favor of Rudy because Rudy is the purchaser, yes? And you also prepare the charge documents in favor of the chargee, which is client bank. Yeah, so you can just mention it there. That's the proper step because it's simultaneous registration of the transfer and the charge at the same time. So you've prepared the documents. So let's start with the charge. You've prepared the charge. What is the next step? After preparing the charge instrument, which is from LRA 53, I think it was mentioned here. Yeah, from LRA 53. After you've prepared, you send this charge instrument to who? To the charger. Not the charger, but this guy, what's it called? Okay, The chargeau, yeah, it's the chargeau because okay, now actually at this point it will be the chargeau because the property will be transferred first, then after transferring it goes to, yeah. So it's sent to the chargeau. The chargeau will have to sign it. The borrower. Yeah. So the transfer instrument is Form LRA 53. So let's talk about the form. Let's just have a look at it. Because they usually, the next time they set the question, they will tell you, give the parts of a charge. What are the crucial elements or crucial bits or parts of a charge? So we're presuming that the transfer has happened and all that. So let me open Form LRA 53. So as advocates for the charge, you've drafted that you've prepared the charge instrument. It has to be properly and validly executed by who? By the charger. Okay, and I'm moving too fast. Let's see LRA 42. Let's go down. This is 52, LRA 53. That's 54. Let's go to 53. Okay, it is. So you've prepared this thing as advocates for the charging. You've prepared. Who do you send it to? The charger. The charger will fill in their details. Cannot passive fill in because as advocates for the chargee, you've already filled it in, but you've prepared everything. You send it to the charger. Why? Because of execution. Yes. Execution of the charge. So the charger has to properly execute. You guys can see the charge here, the charge instrument. Huh? So this is how it looks like. In an exam setting, you won't be told to draft a charge, but you can be told to name the parts or to maybe name some of the key things that I found inside a charge. So you have to have the title number over here. You have to have the date, the charger, who's the charger in this circumstance, Rudy, who's the chargee, Clyde Bank, what is the amount that is being borrowed. There's no supplemental collateral to this in this circumstance. So supplemental collateral, this means whereby other than the charge, you have other collaterals that you will use. Now, other than the description of the parties, one other crucial thing that has to be present in a charge is acknowledgement of Section 90. So this is something, it should be the point that you should, not relevant to this question, but in case they bring it in another question, acknowledgement of the effect of Section 90 of the Land Act. What does Section 90 of the Land Act talk about? Guys, we're about to sit for a conveyancing paper. What does 90 talk about?
I think it talks here.
Yes, the remedies of a charging. So this is supposed to be properly executed by the charger. Execution, verification under Section 45, execution 44, stamp duty inakuwaga ni 46. Yeah, and you're good to go. So that's how a charge instrument looks like. So that you prepare the charge, the chargee has properly executed it. After you send it to the charger also to prepare the charge. So after that, what's the next step? After the charge has been perfected now, not perfected, but has been executed. So it hasn't been perfected yet. It has been executed, validly executed by both the charger and the chargee. What's the next step?
Solonka, if I may.
Yes, go on.
The next step is an endorsement by the chargee's advocate. And by that I mean the preparation of the last documents that we need in relation to this transaction. For example, all the documents that we need, apart from LRA 53, we also have from LRA 9, the other completion documents, the consents that we're talking about, all that.
Exactly. So after you have a properly executed document, the next thing that has to happen is now the advocates for the chargee need to present it for registration. But before you present it for registration, there are the documents that you need to have. Yeah, the supporting documents, the one that Odwar is talking about. And all of these are found under regulation number 60. Regulation number 70. Here it is. Now, Form LRA 9 is the application form. Before you present any document for registration in the lands registry, you will use an application form under Form LRA 9. It's just an application form, also known as a booking form. So it applies actually for anything. Let's call it, the way in civil litigation, you have ways in which you approach the court. Now, how do you approach the registrar, the lands registrar? You're approaching through Form LRA 9. That's an application form or a booking form. And then another name for it, the booking form. So it's just an application form. You fill in the application, the booking form. Yes, that's the application. After making the application, you need now to give the supporting documentation. And one of the crucial supporting documentation is the charge. You need to have the charge, first of all. What else? Now we're talking about more or less just completion documents. What else? Other than the charge, you need to have the title. Yeah. Other than that, you need to have all these documents here. Spousal consent, if it's matrimonial property, land rent, clearance certificates, any other consents, and any other documentation that is needed. So this is a crucial regulation when you're answering that question. So pursuant to regulation 70, you have to prepare all this documentation. Yes. And another crucial documentation that hasn't been listed there will be stamp duty. Stamp duty payment slips. Stamp duty payment slips. So you also need to lodge the stamp duty payment slip. So you need to talk about payment of stamp duty in regards to this matter. So what's the rate of stamp duty when it comes to a charge?
0.1%.
Okay. What about a discharge?
0.05.
Okay. What about a transfer?
Transfer, if it's in municipal cities and town, it's 4%. If it's outside the municipal city, 2%.
Okay. Absolutely correct. So you need to get those percentages very correct. Very correct. So it's 0.1%, sorry, for a charge, 0.05 discharge, 4% if it's within a municipality, that's for a transfer, and 2% outside municipality. So you've gotten that one correct. So you can be asked to calculate. Last year you were asked to calculate the stamp duty payment for a charge. Actually, they gave so many figures and you were told to calculate for various factors. So there was a transfer, and then there was a charge there, and there was also a discharge. So they wanted to test people on how you go about it. So after lodging all these documents, the next step is after getting all the supporting documentation, as Odwar mentioned, stamp duty payment slips, all those documents, all consents, the title, the charge, lodge it to the registrar for registration. And after lodging the documents with the registrar for registration, it's going to be registered. After registered, it's prudent again as an advocate for the chargee to do a post-registration search. Yeah? What is the essence of having a post-registration search in this matter? Why should you do a post-registration search as an advocate for the chargee?
To ensure that the charge has been registered in the charger's name.
Yes, to ensure that the charge has been registered in the name of the chargee, the bank now. Yes. And you have your 10 marks. The only thing that you've left here, and we jumped we jumped because of haste is the professional undertaking. Where will this happen? Where will the professional undertaking happen? It's going to happen at the preliminary stages up there. So advocates for the chargee will issue a peer professional undertaking to the vendor, saying that they will release the funds, yes, after or within 14 days after registration of the transfer in the name of the purchaser and the subsequent registration of the charge in the name of the chargee. Okay, so it will happen at the preliminary stages. Don't forget to mention the professional undertaking and how it arises. I hope you've gotten how it arises. Or maybe do you want me to explain where are you okay? Are you comfortable with how a PU arises in this circumstance?
Kindly explain. Yes.
Please explain.
Okay. The reason why we have a professional undertaking in this circumstance is because of LSK condition number what? LSK conditions of sale, condition 8 to be specific. Let me open it for you guys. So on the completion date, the vendor has various options. Either to pay the funds, the purchaser has various options. Either to pay the funds in, you need to finish completely clearing the funds, the balance of the purchase price. Or if you don't have the balance of the purchase price, you need to give an irrevocable professional undertaking from your financier to the vendor's advocates in the form satisfactory to the vendor. Why is this? Because the financier is the one who will finance the balance. And there's a quagmire here because the financier cannot release the funds before the property has been registered in their name. That's one. An encumbrance has been registered in their name. Yeah, that's one. The other reason is the vendor at the same time, he cannot release the documents. He cannot release the completion documents unless unless he has been paid. So how do we come and cure that kind of situation over there? A professional undertaking will be issued by the financial advocates to the vendor's advocates, saying that the financial will issue a PU saying that within a certain number of days of the registration of the transfer in the name of the purchaser and the registration of the charge, that is when they will release the funds. Now you see, professional undertaking being binding, the vendor once receiving it will know that, okay, even if I release my title documents, they will clear the funds after registration of the transfer and also the charge. And that's where I went and opened this document for you guys. It's actually self-explanatory on this bit. If you read paragraph 1. We act for NCBA Bank, the financial. This is a PU in this matter. So here we can actually change the names. Who was the vendor in this transaction? The townhouse is owned by Ro. So the townhouse here, the vendor is Ro, the purchaser is Rudy, and the financial is Clyde Bank. So in this circumstance, Clyde Bank will issue this undertaking saying what? Saying what? That you release the documents to us. After you have released the documents to us, we will hold those documents in trust until the successful registration of the transfer in favor of the purchaser and the charge in favor of the bank, the client of the bank. Is it making sense now how a PU arises here?
Yes.
Does it make sense now?
Yes.
Yes.
It makes sense. However, I have a question.
Okay, please go
on. How would we rephrase this in the context where we are issuing terms of an undertaking? So I know in this context we are giving an undertaking, but
Yes.
What about the reverse? How do we go about issuing terms as opposed to giving an undertaking?
Okay, that's a good question. Yeah, it's simple. It's just the same undertaking that is here, but you will just add one simple line at the top here. That's the only line you will add. That's the difference. So if you're told to issue terms of an undertaking, now this arises whereby now NCBA will write and say, kindly issue us, we'll write now to the vendor, kindly issue us with your favorable terms for the undertaking. Now as advocates, now for the vendor, you have your terms. How will you issue it? You just do the same. It's the PU, you will do the PU, but then you will add this line on top here. That the following are our acceptable terms of the professional undertaking. Simple as that. And then now you go on ahead and regurgitate now what you want to be in that undertaking, word for word. Is that clear?
Yes.
Okay, that's fine. So,
Solanka?
yes.
Sorry. Just a quick one. I think my call dropped when you mentioned this, but could you kindly repeat who registers the charge? Whose responsibility is it to register this charge? Is it the charges advocates or is it the charges advocates?
It's the charges advocates.
Okay. So,
they're the ones who register the charge.
All right, thank you.
They prepare and also register.
Excuse me.
Please go on.
I've got a question.
Uh-huh.
Me and some classmates of mine have looked at this question before, and one of us raised a concern, not really a concern, but just a question.
Yeah, please go.
We've been told. I can't see the question right now on the screen, but the question about Okay, thank you. The question was about purchase of a townhouse, and it was under the Registered Land Act. So I suppose this was before the migration of titles, whereby when you're talking about townhouses and buildings divided into units, that is, it's the vendor, not the vendor rather, but there was a head list. So the individual holders of the townhouses and the units of the building didn't necessarily have a certificate of title or certificate of lease for that matter. So in this question, the question that was raised is that there's this one head list. So when you're talking about a charge, then how do you ensure that, because obviously in registering a charge, you will need to accompany that question with certificate of title, an original certificate of title. So for this, where there's only one head list, how do you go about it? And who exactly does the registration of a charge in this case? Will it be the chargee, or will it be the holder of the head list? I don't know if you get where I'm coming from. That was a concern raised.
Yeah, I do get it. I do get the question. I do get it. So you No, I do get the question, and it's okay. It's actually true to some extent. Now there's an issue of it being under the Registered Land Act. Now, just starting from there, under the current whenever you're doing this conveyancing paper, just rely completely on, in as much as they've mentioned the RLA, or they bring and confuse and say RTA or maybe G or whatever statute that was repealed, just answer it within the framework of these current legislations, the current laws that we have right now, which is the Land Registration Act, which is the Land Act, the Community Land Act, and the regulations thereunder. So for purposes of this paper, you just limit yourself to the Land Registration Act read together. Now for this question, Land Registration Act read together with legal notice number 278, which you will rely on. But what you've mentioned, what you've mentioned there with regards to leasehold interest is true. Who will register it? Who will register that who will register that, what's it called? That charge, if it's a leasehold interest and then there's only one mother title, it's still going to be the advocate for, okay, no, it's going to be the advocate for it's going to be the lessor or the chargee. I'll have to get back to you on that. I'll go check on a sample leasehold that we've done for a development, these townhouses, and then I'll get back to you on that. Kindly remind me of that. But for purposes of exams, just kindly just restrict yourself to the Land Registration Act, the NNE, and that's going to be sufficient. But when you mentioned that thing, I remembered a crucial thing that we've left out here. And the legal notice number 280. There's a specific consent that we needed. Let me just come here and see. Since you mentioned that aspect of it being leasehold, and we didn't look at it, let me just open it. Give me 2 minutes. But that was a very good question, and it was a very good observation, because this is leasehold and it's not. There's one document again that we left out, if I'm not wrong. This is it. You need to obtain a consent to charge. We left this crucial document because this was leasehold hand, yes? Thank you for mentioning this aspect. This leasehold title for 99 years under the RLA. So one crucial document that we left out here is this. Consent to charge. You understand why it arises, huh? Do you understand how it comes about?
Yes.
Because this leasehold hand from the government for 99 years. Yeah. So I want to introduce some complex concepts here. But if you get a leasehold land, you've been told it's for 99 years, you need to talk about this certain documentation. The application for consent to, you need to get the consent to charge from the government. That's a crucial document that needs to be there. But other than that, if you're answering the question, just, I know it's a great concern, but just ignore. This is what IERA advised us. We raised similar questions back then. This is what he advised us. Don't bother, because they don't expect you to have read the RLA, the RT. It's not in the syllabus. Just use the statutes that came in after 2012. The Land Registration Act, Land Act, Community Land Act, and the regulations there too. Is that okay?
Yeah, absolutely.
But on the question of who registered where there's only one mother title, let me go check with the firm and then I'll get back to you on that. Okay.
Solonka.
Just for knowledge purposes.
Solonka.
Yes.
Hi, I had a brief question.
Go on.
When you were talking about obtaining a consent to charge,
yes.
Just for further clarification,
yes.
Who obtains the consent? Is it me, the chargees advocate, or will it be now Trump LLP, the one that now represents the holder of the lease? Like who will be obtaining that consent to charge?
Actually, here it will be, because there's actually two things. Actually, there's a consent to transfer and there's also the consent for it is. So for consent to transfer, application for consent to transfer, that will be obtained by the vendor's advocate, because it has to be transferred to who? To Rudy. The property will be transferred to Rudy. After it's been transferred and it's in his name, then it's going to be charged in favor of client bank. So for the transfer up to the transfer point, that's the vendor who will have to obtain it. And then now after it has been transferred, the charge will have to be done by the consent to charge. That will be this person, the purchaser now, who is Rudy.
Solanka.
Mm-hmm.
Also, given that now currently the Land Registration Act in the miscellaneous section down there, it repeals the Registered Land Act. Does it now, it's safe just to go that way? Is it not? You just go with the Land Registration Act, even if it is written here, because if it is repealed, then is it not? It is not valid.
Oh yes, no. Where I was saying for purposes of exams, don't rely on, don't even mention or quote any section of the RA. If you want to read it for your own knowledge purposes. But these things have been repealed for purposes of exams. They will only require you to do the exam and rely on the Land Act, Land Registration Act, the Community Land Act. What else? The Land Registration General Regulations, all those legislations, the legal notices that I've mentioned to you, all the regulations, that's what you will be required for purposes of exams. So anything to do with the RLA or RTA, they won't require you to answer or rely on anything pertaining to the RLA or the RTA. Or rather, there is no question that will be brought with regards to the RLA.
Thank you. That's what I meant. Thank you.
Yeah. So, any more questions before we go on? As you've understood the concept of application to the applications for consents, for the necessary consents, yes?
Yes, thank you.
Okay. But I would advise you also you guys to read legal notice, this one, yeah? They've clearly distinguished public land and they've also distinguished private land. I want you guys to go on ahead and get the differences between those two. There's a part on administration of private land and there's a part on administration of public land. And so you've heard of these things to do with land rent and land rates. No? So there's land rent. To whom is land rent payable? Yeah. So just go check on legal notice number 288. It's a very short, like I think 10, 11 pages and you'll be done. And then now, if we get time to do another paper, we will go into those nitty-gritties. So, do we proceed to the next question kindly? And actually, we've answered it. How will you ensure that stamp duty and capital gains is paid in the transaction? So the starting point is who pays stamp duty and the starting point is who pays capital gains tax. So let's begin with that. Who pays stamp duty, who pays capital gains tax?
Solanka, I think the vendor pays capital gains tax and the purchaser pays stamp duty tax.
That's good. Higher. Now, this part doesn't talk about the processes. The process, I think they've come here. Outline the process of payment of conveyance-related taxes. It's under 4. We're just going to talk about how will you ensure. We just mentioned brief to it's the purchaser who pays for the stamp duty, and it's the vendor who pays for capital gains tax. And now we go back to what are the consequences of not paying stamp duty. What are the consequences of not paying stamp duty?
I think that transfer will not be registered as well as the charge.
Yeah, it's one, and registration, yes. Another.
Also, some of these documents will not be admissible in court.
Yes, admissible. Yeah. That's very true. It's under the Stamp Duty Act, very true. The other one?
Non-payment of stamp duty amounts to a criminal offense under Section 113 of the Stamp Duty Act because it's considered as evasion of tax.
Exactly. So those are 3 points you have, and you've also mentioned. So you see how you've already gotten your full marks. So registration, an enforceability or an admissibility of these documents, and also it's a criminal offense because it amounts to tax evasion. And you go straight ahead to the next question. Outline the process of payment of conveyance-related tax. Let's start with stamp duty. How do you pay for stamp duty? Guys, how do you pay for stamp duty?
I think stamp duty is assessment of the, of the consideration to be paid, the subject.
Yes.
And for example, here, stamp duty will assess it from the bank facility of, this is 10 million. Yeah, 10 million.
Yes.
Also
okay, stamp duty, what will the stamp duty be? Will it be 10 million or 20 million?
I'm saying the bank facility is 10 million. So for charge, yeah, so we'll calculate it as 0.2% of the bank facility.
0.1 for the charge. Hello.
Yeah, is it 0.1 or 0.2?
0.1.
Okay.
It's 0.1. Yes, 0.1. Has 0.1 of the banking facility, yes?
Yes. So I think that's it in terms of assessing the amount secured.
Yeah. So it's 10 million. That's 10 million. How will it be 20 million if we are calculating stamp duty between who and who?
I think it will be 20 million. I'm guessing 20 million is the contract rate that you're using because the question says that 10 million is 50% of the balance of the purchase price.
Yes. So, okay, there are different transactions happening here. And this is what actually came to our exam. So if you're paying stamp duty for the charge, it's going to be for the 10 million. Yeah? For the consideration, which is 10 million. 10 million, the amount, 10 million times 0.1%. If it's for the transfer between now the purchaser and the vendor, the property is worth, because they're saying you paid 50%. So it's 50% of 10 million. Okay, 10 million is a 50%. So the other 50 is 10. So cumulatively, that's 20 million. So 20 million is the transfer or the valuation of the property, 20 million, which will be times 2% or times 4%. Okay, in this circumstance, it's within a city, it's within a municipality, so it's times 4%. Stamp duty will be 4% of 20 million for the transfer, for the sale agreement between the purchaser and the vendor. And as Forrester mentioned, for the charge, it's 0.1% of the 10 million. Okay. Now, the process now. Now here they're talking about the process, step-by-step process of paying stamp duty. It usually starts with, I believe you're writing, it usually starts with presenting the documents to a valuer for assessment. Okay. The government valuer. So you present the documentation for the government value for assessment. After you've presented the same, it's assessed. And by assessment, they'll just say, tell you this amount you're supposed to pay. After the value is done and assessed, you will now endorse those forms. Basically, it's just a red thing that usually it's at the corners of the charge instruments or maybe the transfer or the sale agreement. And after it is done, what will happen is the next step is just go on to iTax, carry website. And you can see here, it's automated right now. CGT, stamp duty, all these things have been automated. Not carry website, but iTax, sorry. Okay, so
maybe I have a question on you have said that
the document subjected to the valuer, but I thought it is the land registrar, because you know this is not a transfer, there will be no need for valuation. So the document presented to the land registrar, who will assess the amount to be paid, so that now the person can now proceed to the iTax.
Okay, now, no. So you see, when you go to those offices, there are different departments. So this one, it's the collector. There's this person, collector of stamp duty, and there's a government valuer. So it has to go first to the government valuer, because even for charges, it's not necessary for you to do valuation, because the sum is what the consideration is. The consideration is simple. There's no valuation because the consideration is just simple. Whatever the consideration is between the financier and the borrower, that's what will be used to calculate the stamp duty for the charge. So it's not necessary to present this document for valuation. It's true, as you mentioned, it's not necessary to present this document for valuation, but in a typical stamp duty exercise, it's not even going to the land registrar. You just go on ahead and pay and all those stuff. But for all conveyance-related taxes, stamp duty, how is it calculated? How is it assessed? You first have to take it for assessment by the government valuer to determine what to be paid.
I have a question, because it is both a transfer and charge, or it is part charge. Are you saying that the other part of the purchase price, we don't have to pay stamp duty on that? Because if you're not going to value it, then how will you determine the value? Because I thought the valuer values, and then we'll do away with the 10 million out of that value, and whatever remains you pay either 2 or 4, in our case 4%.
Okay, now for the transfer, the valuation will be done on, here they say an assumption is made that the value of the property is agreed between Rudy, and the time is January 2017. So I think from the question, they're just saying that the value of the property is from the sale agreement. What's the consideration with the full consideration, not the balance, not the part payment, but the full consideration is 20 million.
My question with respect to if it was not a question and it was part, say in practice, it is part financed and part not financed.
So which stamp duty are you paying for the transfer or for the charge?
We want to pay stamp duty for the transfer.
For the transfer, it's the value of the property.
So we have to take it to a valuer.
You have to take it to a value.
Oh,
yes.
Okay.
Yes.
And when the valuer determines the value, will he subtract the 10 million or whatever is financed?
No, he doesn't subtract anything whatsoever in that circumstance. It's just the value that he determines, and that's the value that will be used to calculate stamp duty tax. So you see, what happens is, their sale agreements, practically speaking, you will find why does this thing need to go for valuation? People may agree in the sale agreement that the vendor will say, okay, pay me 5 million, but the value of the property is 30 million. What will be used, maybe to you, what will be used to calculate stamp duty in that circumstance? The 5 million that is in the sale agreement, or the 30 million that has been assessed?
Whatever is assessed.
Exactly. So whatever the government value assesses, that's what will be used as the consideration to pay stamp duty. That's fine, yes? Now, if it's just a charge alone, there is no need, but at the same time, you still take it to the government valuer for that. There's that kind of, practically speaking, there's that endorsement that is there's a red thing that is usually done. We call it, I think, franking or something. Yeah. So it's prudent to have it for you to now proceed to the next stages. Okay. So after valuation, what happens? You log on to KRA, or the iTax portal, or the iTax platform. Okay, I'm seeing guys saying that Wanatolo are meeting. Somebody just tried to call me. Kindly don't remove anybody from the meeting. Kindly. I think we're not even full. We're not even 200 people here. So it's just don't remove anyone. It's polite not to remove anyone. So after valuation, the next step is logging on to iTax. What else? You pay the amount. You go pay the amount to a government. What government? It's just KCB. You go to KCB, pay the amount. amount that has been assessed. After paying, you now return the documents together with proof of payment to the collector of stamp duty. And after that, the documents will be done what? The documents will be franked. Like there's a red thing that is given at you have the charge, or maybe you say the transfer. It's just, you'll see it practically. Right now, it's of no essence, but you'll just see it practically when you do your pupillage. So after it's been franked now, I think you're done with the process for paying stamp duty. Assessment, simple process. Take the documents for assessment, for valuation. After they've been valued, go on to the iTax portal, pay for them, some through a government, just KCB, I don't know how to put it in English, but just KCB bank. You go pay for the tax. After you've paid for the tax, you go on ahead and now return the documents to who? To the collector of stamp duty. So there are two people. There's a government valuer, there's a collector of stamp duty. After you have done that, the documents are franked, and that's the entire process for paying stamp duty. Now, somebody assist me. What about capital gains tax? How do you pay for CGT? It's not in the question, but how do you pay for CGT?
Solonka, a question just said that once you return the document to the collector of stamp duty, you tap the document?
Franking. It's franking. Franking.
Maybe to add,
yes.
The franking, the document is drawn for registration, and you are given a booking form which you will use to correct the document after registration.
Yeah. Okay. Now, okay. Practically, the booking form is for Mail Array 9. That's actually a good one. It's a good one. I think you've done conversing practically speaking. So yes, the booking form is for Mail Array 9. So after you've left the documents for registration, there's a time now you'll be called, and the reference document from your end and the registry is the booking form, which is just from LRA 9, the application form that we talked about initially. Franking is just simple. It's just stamping the documents. You know, what evidence do you have that the documents, the stamp duty has been paid? It's the franking that has been given. The franking of the documents.
Okay, thank you.
Okay, that's fine, yes. Now let's go to CGT quickly, then now we proceed. How do you pay for CGT? And how is CGT calculated? Okay, stamp duty. Okay, for CGT, let me see if I can guess to you. They bring this question last year, I think they did. So for stamp duty, what is taxed?
The gain.
And how do you get the net gain?
The transfer value minus the cost, minus the adjusted cost.
Yeah, minus the adjusted cost. In simple terms, what they mean is, let's say you bought this property. It's Raw Limited, yes. So they're selling the property at 20 million. Or is selling the property at 20 million. Or okay, selling. We just put selling. Or is selling the property at 20 million. We have who else here? Rudy is buying. Not Rudy. Ro bought the property at 10 million. Ro developed the property at what is it, at 2 million. So whenever you're told to calculate stamp duty, first of all, you never even mentioned what is the stamp duty percentage? You've mentioned for transfer, it's 4% municipality, 2% outside municipality. What about stamp duty? What is it? It's 5%. Okay. So net gain, how do you get it? So it's 5% of the net gain. 5% of the net gain. This is how you calculate stamp duty. It's a question that is usually tested, 5% of the net gain. So what is the net gain in this circumstance? The transfer value minus the adjusted cost. The adjusted cost encompasses the property, what consideration did the vendor buy the property for initially, plus any other improvements or developments, enhancements, whatever costs they've used to maintain or enhance or develop that property, all forms part of the adjusted cost. So 5% of the net gain will be, you first need to calculate the net gain. And the net gain is the transfer value, which is 20 million. That is the property in which Raw is selling, minus what? They bought the property at 10 million and developed it for 2 million. Yeah. So what do you get there? 20 minus 12 million, which is 8%. So how do you calculate the capital gains tax? 5% of 8 million. Okay. Then you get your answer. That's the no stamp duty, that's the CGT, capital gains tax. That's how you calculate the CGT. Any questions on that?
Solanka, just a minor question. The main reason it is 10 million is because, or the reason is because now the other 10 million was sought after paid by the finance.
No. That's a fictitious figure.
Am I just confused because maybe you can elaborate further?
Okay, sorry. That was a fictitious figure. I was just explaining how you calculate stamp duty. Not stamp duty, CGT. CGT is tax on the net gain. Tax on the net gain. What have you gained from this property? Tax on the net gain. Yeah? So leave alone this question. Let's use me and you. I can see your initials here, KK. So KK, you're the vendor. 10 years ago, you bought this property at 20 million. Okay, let's say 100 million. You bought this property at 100 million. Okay. Very prime land in Canada.
Yes.
Then that was 10 years ago. Now today, you are disposing of that property and you found a seller, and the seller is buying it at what? 200 million. Okay. Now over the years, when you bought that property, you incurred costs. For instance, you fenced the property. What else? What else do you do? You've developed the property. You've preserved the property and everything to a tune of, let's say, 20 million. You've developed the entire property for 20 million. How do you calculate stamp duty, not stamp duty, capital gains tax on that? The formula. You need to get the net gain. Okay, stamp duty is just 5% of the net gain. Okay. Percent of the net gain. So how do you calculate the net gain? The net gain is just the transfer value minus the adjusted cost. It's just a matter of putting figures. Of putting figures here. What is the transfer value here, KK?
The value for transfer is 200 million.
Exactly, 200 million. Yes. Minus, what is the adjusted cost?
You less the 20 million and the 100 million for the initial buy, or am I?
Yes.
Not so sure.
Correct. You're correct. The adjusted cost is basically the price in which you bought the land plus any developments that you've incurred, any developmental costs that you've incurred over the years. So you've developed this property for 20 million and you bought it for 100 million. So the adjusted cost is just 120. You bought it for 100, developed it for 20. It's just 120 million, 120. So what you're doing is you're just taking the 200 million minus the 120 million. What do you get? 80 million. 80 million is the net gain. Yeah.
Yes, I'm
So 80
following.
million times what? Times 5%. And then you have your CGT. What's 5% of 80 million?
Oof. Let me get my calculator.
What's the... Who's calculating that? ATM times. It's 4 million, huh? 4 million is a CGT that has to go to the government.
4 million. Thank you very much. Thank you.
Have you understood? Have you all understood how you calculate capital gains tax? It's a question. They brought it in our exam paper.
I'm very grateful. Thank you.
So anyone has a question on that also? Does anyone have a question or concern or something that you need me to clarify? You've understood how you calculate how you calculate all those documents, yes?
Salonka, what if you are selling the property at a loss?
Okay, if you're selling the property at a loss, you don't calculate any capital gains tax. There's no CGT there you're going to pay. Because there's no net gain. So there's no CGT. If it's at a loss, you can't do 5% of the loss. No. So if you sell the property at a loss, no CGT.
5%. 1, 2, 3, 4, 5, 6. It's 4 million. Wow.
Anyways, okay, let's go on. That's how you calculate CGT. Maybe if you get the last year's paper before we finish, if we finish early, we can go through the question on CGT and how it's calculated. So let's go to the process of payment for land rent and land rates. How do you pay for this land rent and land rates?
You pay them at the SASA website.
Yeah, nowadays it's at the SASA. It's been automated at the SASA. And but even before we go on to that, to whom do we pay land rent and to whom do we pay land rents? Let's start with that. It's a very tricky question, but let's start with that.
Land rent, the government. Land rent,
government. Are there circumstances where you pay land rent to the county government? Land rent, not rate, land rent.
Land rent is paid on leasehold property, so it's being paid to the national government. And then land rates is being paid to the county government, as in the local authority at which the land is situated.
Okay.
You can
so do we pay? Yes, okay, that's true. It's just a simple yes or no. Do we pay land rent to county governments?
Yes.
Yes,
why
there is that?
Yes, why is that?
Where the head lessor is the county government and not the national government.
Exactly. You can clap for yourself. Yes, that's very true. If the head lessor is, you can have the head lessor being the county government. If the head lessor, if the head lessor is the county government, you'll pay the land rent to the county government. If the head lessor is the national government, you will pay it to the national government. Okay, but for rates, that's the county government alone. Okay, now when you talk about payment of land rent, yes, it's true. This thing has been automated. It's at SASA. But in an exam paper, it's actually prudent for you to just cite the law and mention some of these bits. Yeah, it's good. Just mention the law and this is to do with payment of land rent. And which legal notice is this? Legal notice number 280. So in as much as it's at Lisasa, just mention legal notice number 280, go on ahead to land to regulation number, just so it's right here. Regulation number 11. So this is land rent for public land. Where do you pay through who? Who do you pay through? You pay through the commission. The commission is the National Lands Commission. So the commission will issue land rent demand notes to the lessees. Land rent shall be paid into a bank account designated by the commission. Where the national government is a head lessor, the commission shall remit the funds into the consolidated fund account. And where the county government is the head lessor, the commission shall remit such funds into the respective county revenue fund. Yeah, etc. So you've understood how circumstances where you pay land rent to the county government and circumstances where you pay land rent to the national government. That's the process of paying land rent. It's as simple as that. For public land. Private land. Now, private land, we're talking about, in this circumstance, land. You see these lands, these leaseholds that have been given under what? For 99 years, they are classified as private land. Okay, in as much as it's from the government, it's classified as private land, but the government still has a say in it under legal notice number 280. This is why I was saying it's very important for you to read this legal notice. So for private land, when you talk about payment of land rents, let's see. They have it here. Okay, just in a bit not to waste time, but yeah, it's just the process is just the same. Under legal notice number 280, we pay through a government designated bank, then it's remitted respectively depending on who the head lessor is, and so forth. So I think we're done with that question as of now. Yes, please go on.
Talking about the land rent and land rent, having known that the business amendment laws repealed the respective sections 39 and 38,
yes,
the Registration Act, which required obtaining of these consents. So when answering a question and you're told to talk about these issues, how do you go about it knowing that the same has been repealed, but then it's still appearing in other legislation such as the conditions
regulations?
This regulation you have just mentioned. How do you go about it?
That's true. Now, the starting point is the Section 39 were amended. By virtue of amendment, what did it mean? That amongst the completion documents, you don't need to avail what? You don't need to avail the land rents clearance certificate or the land rates clearance certificates. Up to that, that's very true, and that's valid. But the question now you ask yourself is, what happens? Let's say land has outstanding rates totaling to 1 million, and you're an advocate for the purchaser, and you don't do your due diligence to require for this thing. In as much as it's not an obligation, under the law, it's not required for registration. Not required for registration is different from if that liability will be transferred to your client. Yeah? So it's part of due diligence as an advocate for the purchaser. You need to investigate and see if there are any outstanding rent or any outstanding rates. And how do you determine this issue? You determine it by having a look at those clearance certificates. Yeah? So in as much as it has been repealed, it still forms part of the duties of the advocates for the purchaser to determine whether there are any outstanding liabilities, and these outstanding liabilities can come in the form of rent or rates. Because if the registration happens, yeah, and later on those liabilities have been transferred to your client, as an advocate, you'll be liable for professional misconduct. Yeah? And also, it's not good practice to maintain clients. You should ensure that your approach to certain transactions is above reproach. So that's how you will approach that question. In as much as it has been amended, there's an aspect of diligence. You don't need that. You don't want that liability to be transferred to your clients. Is that fine? Well, the reason why I'm opening this interpretation of general provisions is because of another clever argument that maybe you could bring into it. Let me just here, section 24 of what? Of the Interpretation and General Provisions Act. What does it say? When an act or part of an act is repealed, subsidiary legislation issued under or made in virtue thereof shall, unless a contrary intention appears, remain in force so far as it is not inconsistent with the repealing act until it has been revoked or repealed by subsidiary legislation issued or made under the provisions of the repealing act, and shall be deemed for all purposes to have been made thereunder. So the Land Registration Act was repealed, but Legal Notice number 278 was not repealed. I mean, it was amended, but Legal Notice number 278 of 2017 wasn't amended. So if this thing actually even ever spirals to court, you could use this provision and argue it out. There is no contrary intention or there is no inconsistency between the parent legislation and the subsidiary legislation, and it still stands. The subsidiary legislation still stands, and it requires you to produce or reduce the land rent clearance or the land rent clearance certificates. So there are two ways in which you can go about that argument. You can use the Interpretation of General Provisions Act, and you can also use the aspect of due diligence or the command rates of an advocate. Is that fine? Pampa? Not Pampa, sorry. Deche, Mkambi. That's fine, huh? You've understood how to approach those things. You can approach it legally speaking and talk about it 24. Or you can now argue the other way, the one that I began with. Yeah. So are we satisfied with question number 1? We can now move on to question number 2.
Yes, please.
Let's go on to question number 2. Somebody please read question number 2. Anyone?
You act for party. You can proceed.
You act for Patrick. He intends to purchase a commercial building within the central business district of Nairobi. He is in a hurry. He has to leave the country in under 1 week for a minor medical procedure. He brings to you a search certificate. The search certificate, which is undated, reveals that the property is registered under the now repealed Registered Land Act Cap 300, and the proprietor is Kikau Management Limited. It is a freehold. Several leases are also registered against the title. Patrick, who has been accompanied to your offices by his 30-year-old son Chris, is worried that in his absence, the transaction may fall through as the vendor's agent has given him only 7 days to execute the sale agreement, which has been drafted by Noreen LLP. You have your reservations and will want to amend the sale agreement and also conduct the requisite due diligence. A, explain to Patrick the mediums of investigation of title that you intend to conduct and why. B, advise Patrick on how you may be able to conduct and conclude the process even in his absence and what he needs to do. C, Chris, who is worried of his father paying a huge amount in deposit, asks you to advise both of them on how you may secure the deposit in the event the vendor becomes insolvent before the transaction is completed.
Thank you. 22 mbio mbio. I remember when we were doing orals, we talked about the mediums of investigation of title. So what are these mediums? There are three main ways. Which ones are they? Three ways of three main mediums of investigating title. Guys, remember. Okay, I'll list them and then I'll explain. Okay, please. One, you have?
We have contract.
The contract inquiries,
Requisitions.
Requisitions. Searches, Hi, now explain all these three and give the law and statutory underpinnings, if any. Let's begin with searches. Where do we get searches from? And what is the essence of a search?
Official section 34 to 36 of LRA.
Yes, there's 34. 34 is on searches. So what are the types of searches we have?
Personal historical.
Yeah, personal and historical. So what is the essence of a search?
To ascertain the
and then encumbrances thereupon.
Exactly. So you do a search. It's just a medium of investigation of title. A search will show you who the proprietor is. It will show you any encumbrances on any encumbrance that is on the title. What else? What will a search show? Sorry. What will a search show? The encumbrance, the proprietor, and so forth. No? So the other benefits of having a search is because of, you guys have heard of the torrents principle, yes? Or the torrent system or the torrents principle. The curtain, mirror, and the indemnity principle, yes? So in case you do a search and then, you rely on the search, but there are some certain defects on it, then you can seek for compensation from the government. Okay, so that's the essence of a search. Now, for the historical search, the essence of having doing a historical search is because of this thing you people have heard of, known as the Ndungu report. Now, the Ndungu report is historical lands injustices. It's very risky for you as an advocate to let your client buy property that is in that report. Yeah? Because you're paying land. So that's the essence of doing the historical search. You need to go to the root of the title. Roots. Go beyond the search. Go beyond the official search. Look at the root of the title so as to determine the validity of this, the historical roots of this title. What other kinds of searches will you do here? What else? Will you go to the company's registry? Maybe it's just a question to you guys. Will you go to the company's registry?
I think because it's an LLP, and I think from our commercial law transactions class, we said a registry for both LLP and companies is the same, and that's the company registry. But that's just a guess. I'm not so sure, but I think you would probably go there.
That's true. Now here we have this thing. What's it called? It's not even the LLP, but we have Kikau management.
Oh yeah. Sorry about that.
So yes, so that's true. So you have to go do it in the company's registry. You need to know the director, what are the people behind, what are the faces behind this company. Yeah? Because the company by itself cannot sign. Kikau management won't come there and sign the documents. It's directors, it's agents will be the ones who will sign this sale agreement. So you need to do it. Determine who are the faces, who are the directors, so forth. So it's part of due diligence. Those are some of the things to check out when doing a conveyancing paper. What else is there? What else will you check with regards to searches? Have you exhausted everything? Maybe you have. Next time you can check. You can.
I have a question. When you're talking about the company's registry, can you just say CR12? Can you just say?
Yeah, by that's a CR12 you're asking about. Yes, you need to do a CR12 search.
So in the exam, if you say CR12, no one will penalize you because it's basically the same thing.
Yeah, no one will penalize you. No one will penalize you. I hope you have not interacted with CLE lecturers. I don't know, but they won't penalize you. Legally speaking, a CR12 is a company search you're talking about. So just to be safe, just write a company, do a search, the company's registry, into brackets the CR12 search. You may find the person who's marking your exams doesn't even know what a CR12 is. Yeah, just speculating. Doesn't know. What is this? Just to be safe, write everything there. There's actually going to be 3 words: company search, brackets, CR12 search. Get your marks. Yeah. So, yeah.
I think you'll also need to do a physical search. And a physical search.
Okay, a physical search.
Yeah, the importance of this is under condition 4.3 and 7.35, where if you don't go and confirm the physical status of the land, then you buy the land as it is once completion date has reached. So it's quite important that you have. Yeah.
Yes. Now actually we're moving on to this. This is now what we call the pre-contract inquiries. The pre-contract inquiries. Yeah. This is what I call pre-contract inquiries. It entails just visiting. Today I'm doing visiting. It entails visiting and checking the property, the physical state of the property. Yeah. So pre-contract inquiries, the reason or the basis for this is because of one crucial thing. The search may not show everything. You need to go there, physically inspect the property to determine any patent defects on the property. You also need to go down there and check who are the people who are occupying this property. You need to check your neighbors. Yeah? You need to check at what else? The development prospects of the area. So, you may go to a certain area and you're told you cannot put high-rise buildings over here. So it's crucial for you as part of due diligence or as part of investigating title to check into that. And just going to check the condition of the land, to go check the boundaries, all those things, and you're good to go. That's pre-contract inquiries. And the last one now is requisitions. So what's the statutory underpinning? I once explained to you guys about requisitions. What's the requisition and what's the statutory underpinning on requisitions? Not statutory per se, but where can we get the law on requisitions?
LSK condition
LSK condition 6.2,
6.3 there.
Yes, go on, explain it.
Requisition, you are simply requesting for the title, title from the one who is selling it, from the vendor.
Yes.
And then you are giving a professional undertaking that you will only use the title for requisition only, and you will return it at the request of the vendor.
Yes, that's absolutely true. So requisitions are just any questions that will relate for the title. So what happens is after 14 days, you have to begin here. We have to, just read condition 6 in general. But what happens is after 14 days of execution of the agreement, the vendor will have to deliver certain documentation to who? To the purchaser or the purchaser's advocates. Certified copies of the title, certified copies of the deed, all these documents that are here that you can see on my screen. Within 14 days of the agreement, the vendor will deliver these things to them. the purchaser. Now, the purchaser, after receiving them, will engage in a process known as deduction or deducing of title. So he will check the documents, look at the titles, and basically just look, see, are there any problems from the face of it? I'm looking at this title, or you've sent me the title. The title is saying there are two owners, but in this entire transaction up to date, I can only see only one owner. These are some questions. So after he has looked at the titles 14 days after receiving those documentation, the next step for him is to raise any repositions or any objections or any questions with regards or pertaining to those title documents. That's part of due diligence. Any questions or objections that arise after deduction of title, that is a requisition under condition 6.2 of the LSK conditions of sale. Okay, and you're done with that question. So you just need to tie down those mediums of investigation to the facts of the question, and you get yourself the marks, and you're good to go. Now, part 2, advise Patrick on how you will be able to conduct and conclude the process even in his absence, and what he needs to do. So what do we need to do here?
Salonka, I think you can execute a power of attorney either in favor of the advocate or his son.
Either in favor of?
The advocate or his son.
Okay, now we've gone on to powers of attorney. Where under the legal under the legal notice number 270, under what? Condition what? Not condition, sorry, under regulation what?
I don't remember.
Okay, we'll just check it out. But there's usually from LRA 567. 5 general power of attorney, 6 is special specific, sorry. And then you have the other one which is irrevocable, sorry. So can you just tell me the difference between all those three? Or highlight what are the types of professional undertakings? I mentioned from LRA 5678. I think it's 567 for the 3 types. Specific, the general, and irrevocable. What's the difference between the 3? From LRA 5 is the general, LRA 6 is the specific, and LRA 7 is the irrevocable. So yes, what's the difference between the 3?
Salonka, for the specific, it gives the Donald the specific powers. For example, in scenario to act on a particular property. So it is limited to particular property. Whereas when it comes to general, it gives the donor various powers, and you will find that the power is not limited to a specific task. They can do many other things.
Anything and everything, yes?
Yes.
Yes, for general powers of attorney, it's broad, it's general from the wording. Can do anything and everything. For specific, it's only limited to certain aspects or certain activities. That's specific. Now, what about irrevocable power of attorney? Anyone with a clue or an attempt? Who wants to attempt? What is that crucial thing that is in an irrevocable power of attorney? Makes it irrevocable. Yes, I've had somebody say the answer.
Consideration.
Yes, that's the answer. So if you look at from LRA 7, which is for the irrevocable, there's a consideration here. So for irrevocable, there's consideration that is given. Yeah. There's consideration irrevocable. If we go on ahead and look at a specific, there's no consideration, and it's limited to certain factors. This is Form LRA 6. If we go on ahead and look at Form LRA 5 for general, there's no limitation. This guy can do anything and everything. Yes. To be attorney of the denote and generally in relation to the to do anything and everything. Are you getting the difference between all those? Anything and everything. This one is that is for general LRA 5. LRA 6 is for certain to do the following. It's limited to the specific acts. And then for irrevocable, the reason why it's irrevocable is because of the element of consideration. It's our circumstance. Hi, guys, I think we're done with question number 2.
So long.
Yes.
Just to add to irrevocable power of attorney.
Yes.
Apart from the fact that we have consideration, of course, I think we also have to emphasize that it must be measurable benefit, not just consideration. It must be something valuable, something sufficient. So, for example, love and care would not suffice. Then, again, if you look at the case of CCB versus MIB and AgriSeed Company Limited of 2012, I don't remember, we have 2 elements. Apart from valuable consideration, the document must also state that the power of attorney is irrevocable. So it must state that it is irrevocable, and we must also have valuable consideration. Thank you.
Well, thank you for that. I've learned something. I've learned about that case. Thank you for that. Thank you for that remark.
What are situations when the irrevocable power of attorney is issued?
Yes.
When can this irrevocable power of attorney be issued? Can you give an example?
Now, you see, now the effect of having an irrevocable power of attorney is that it cannot be revoked. So thinking of a practical example, I cannot come up with any right now because I think any situation can present itself where you use an irrevocable power of attorney. The key consideration is just that aspect of consideration. You've given something for this irrevocable power of attorney. So that's it. Maybe my colleague who just spoke right now, because he mentioned a case. In what circumstance was that irrevocable power of attorney used in that circumstance? Odor?
Okay, the case is, I see someone's asking for the quotation, CCB versus MIB and AgriSeed Company Limited of 2012. Now, in relation to the question that someone just asked, in this case, an irrevocable power of attorney was given, but it was given for exchange of, just love and care. Just the fact that someone loves you so much and they care so much about you, then they decided to give this person an irrevocable power of attorney. So in this case, they stated that just love and care is not enough. It's not valuable consideration. So here, yes, the power of attorney stated that it was irrevocable power of attorney, but there was no valuable consideration. So that is what the case is about. But I think just the way you stated, Solonka, like we have freedom of choice here. You can go for specific, you can go for general, you can go for a revocable power of attorney. So I think it's a matter of choice, really. If I want a revocable power of attorney, then I can decide and go for that. Then maybe, Solonka, just to add to what you stated, I think when it comes to this power of attorney irrevocable, it's a special case, and it only terminates where we have incapacity, of course, of the person who has donated to, or we have death, he has died, or any other legal reason, for example, bankruptcy and the rest. So it's a bit, how it terminates is a bit different. So just the way you stated, it's a matter of choice, in my opinion. Thank you.
That's true. Thank you for that.
Solonka?
Yes?
In this question, when you talk about the power of attorney, are you supposed to advise Patrick which one he should give you? Like, should you say say that you prefer, if you had now as his advocate, a general power of attorney versus a specific one, or is it worth mentioning which power of attorney is preferable, or leave it at mentioning the various types? Are you supposed to lean towards which one is preferable, or is it sufficient just to mention that that you as the advocate can conduct Patrick's affairs if you have a power of attorney?
Yeah, that's true. So maybe the question is, since they haven't limited you, we can talk about the advantages and disadvantages of each. So you can mention where general is specifically, and then down there conclude why you will think this one is fit based on your answer. Somebody will say general, somebody will say specific. But of importance is you've already answered the question that it's a power of attorney. So it's totally fine. You can. Yes. Now we can go on to question number C. Chris is wary of his father paying a huge amount in deposit, asks you to advise both of them on how you may secure the deposit in the event the vendor becomes insolvent before the transaction is completed. So someone, what is that?
Next question.
Go on.
I question on not only just now that you've mentioned it. Is there a specific like incapacity that a donor should have before he appoints or he gives someone a power of attorney? Like, is anybody? I can use illustration. I'm saying like as long as today decided that you want your son to execute or to carry some specific duty on your piece of land, it is not that you have any issue or any problem, any difficulties, only that you've decided. Is there any legal requirement that you must have a certain capacity? Thank you.
Okay. Now, the capacity we're talking about just relates to age and what else? Age and the mental state. Yeah, you should have the requisite mental state to enter into a power of attorney, or to conclude a power of attorney, or to grant a power of attorney, and also the aspect of this one. I'm forgetting this one on the issues of undue influence and duress. So yes, these are some of the elements of capacity that we need to look at: duress, undue influence, the age, not a minor, obviously, and sanity. So just the free state of mind coupled with the age and capacity. Yeah. Now, guys, I've already opened the answer for you on part 3. Chris is wary of his father paying a huge amount in deposits, asks you to advise both of them on how you may secure the deposit. How would you go about this?
Solonka is okay.
Yes, please go on.
Yeah, so if you look at the conditions, just apart from, of course, what you are projecting, if you look at the meaning, deposit and the meaning of purchase price, so you'll realize that yes, this guy is paying a deposit. So a deposit means sometimes it's 10% of the purchase price, but maybe the seller agreement could say something that is different. Now, coming back to what you've projected, if you look at 5.11, it states, unless otherwise agreed in writing, the purchase price shall be paid by RTGS or other electronic means to the vendor advocate's client account maintained in the bank. So I think it's very important for us, first of all, to see there or recognize that they're saying this amount will be paid, yes, but this amount is not paid directly to the vendor. The amount is paid to the vendor advocate's client account. So the money is not going to the vendor's account, but the vendor's advocate client's account. And subsequently, if you look at 5.21, it states that this amount that has been paid will be held by the vendor's advocate as a stakeholder. So in the event that anything happens, then, issues of professional ethics, are in question here as a stakeholder, the vendor. So they're saying, how can we secure this? Since now we have an advocate who is holding this money, it's my opinion that we only need a professional undertaking from this advocate that in the event that this happens, then I will give you back the money. But because of legal, backing, 5.21 that says that, he holds this money just as a stakeholder. And of course, that means if anything happens, then they're supposed to give it back to you. Then I think there will be no problem. But just so that this guy is, very, very secure. He has something that he can see, substance. He's reassured. I think you can ask the vendor's advocate, since he is the one or she is the one holding the money, to issue you with a professional thing stating that in the event that anything happens, including this insolvency, then they'll give you back your money. That would be my answer.
Yeah, that's actually the answer. Stakeholder. Or maybe escrow. You've heard of escrow accounts, other names, escrow accounts, stakeholders, and so forth. So the answer is simple. Just under section, the answer is simple under section, not section, but condition 5 of the LSK conditions of sale is that the deposit will be deposited in the vendor's advocate's account, or in the vendor's advocate's account as a stakeholder. Yeah? As a stakeholder. That's actually the answer. There is no other way you can answer for 4 marks, just giving 5, talk about stakeholders and so forth.
Would the would the PU help?
Would the PU help? Okay, who is paying a huge deposit? No, okay, now maybe explain to me. Let's discuss it.
Attempt in discussed earlier, but could maybe an agreement between okay, advocates, that in the event of
between the advocates, yes.
Yes, please say that in the event that the deal falls through or is rescinded by either party, then the paying party, the purchaser will be or the purchaser's advocate is meant to receive the money, or like money paid deposit already. So yeah, would such an arrangement work in the event that the deal falls through? I have my money returned, maybe minus charges or maybe other costs imaginable. For example, rescind and etc.
Then, Solonka, before you answer, I don't know if you mind. Solonka, you're muted.
Oh, sorry, go on.
Yeah, so this is my thinking. If you look at 5.11, I don't think it's an automatic decision. If you look at it strictly, it is saying unless otherwise agreed in writing. So where it is agreed in writing, then we have an exception. So it's saying unless otherwise agreed in writing, the purchase price should be paid by RTGS or other electronic means to the vendor. So that means we could have situations where this actually doesn't happen. The money goes straight to the vendor. So in that instance,
hey, what's happening?
How would you? You can hear me? Hello, Solonka.
I can't hear him. Odwar, go on.
Yeah, you can hear me?
Yes, I can hear you now.
Yeah, so I was saying we have to be very careful with 5.11. And if you realize, you'll see that it states unless, and we have to underline that, unless otherwise agreed in writing, the purchase price shall be paid by RTGS or other electronic means to the vendor advocate's client account. This means, if you look at that statement, it means that in some circumstances, this actually would not happen. And the terms of the contract, of course, as we all know, is what would take precedence. So where it is agreed in writing, where what is in writing is stating that this money does not have to go to the vendor's advocate, vendor advocate's client account, it doesn't have to be paid by RTGS, then that would suffice, because they're saying unless otherwise agreed, to mean there's an exception to this general rule. So this is what I think. In the event that 5.11 is not followed strictly and the money is not paid to the vendor's advocate's client account, of course, paid through RTGS, then if you have a professional undertaking from the vendor's advocate account, stating that, yes, fine, we haven't followed 5.11. The money has gone straight to your client. But this is what I want. In the event that anything happens to your client, I want you to undertake that you will actually refund me this amount of money. So I think to that extent, then the PU would be of help. So of course they can say yes, or they can say no. So in the event that they say no, 5.11 will work automatically. Of course, the laws are that you can't issue a professional undertaking unless you have the money in your account. I don't know if you understand what I'm saying.
Yeah, I'm getting the argument. So you need to remember these are contractual from the onset. These are contractual relationships. Being contractual relationships, parties are free to choose how they go about it. Yes, but here they're talking about how will you secure the deposit in the event of the vendor becoming insolvent. So one option that is clear-cut, it's the issue of stakeholder making or paying the sum into the vendor's advocate's client account, and him being a stakeholder for the sum. Now, I'm looking at the argument on professional undertakings. In as much as it cannot be discredited, it's a valid argument. But then let's look at it practically. The vendor's advocate is issuing a PU. The vendor's advocate is issuing a PU. The PU will be to the effect that he will pay back, or whatever I'm getting you clear, that he will pay back the sum that has been put in his client's account.
So like what I was saying, in the event that, you see, if you look at 5.11, it's saying unless otherwise agreed. So where we have a contract, of course, the way you said, the parties are free. We have a contract stating that 5.11 will not be followed. The money will be remitted to the vendor's account. Now, to that extent, of course, you can't, say that 5.21.
Now I'm coming here to the vendor's account.
Yes, the money is now going straight to the vendor's account. The money,
vendor's account, okay.
Yes. Yeah, so to that extent, we can't talk of 5.21 because he doesn't have the money. He's not holding it as a stakeholder. So we don't have that as a remedy. Yes. 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 So you ask him to issue you, now that we don't have any remedy under 5.21 and 5.11 is not applying, you ask him to issue you with professional undertaking, stating that in the event that anything happens, for example, here we have insolvency, then since he's personally liable in a PU, if you look at the essential elements of a PU, you ask him that if anything happens to his client, who is the vendor, then he will be personally liable to pay you this amount of money. Of course, for him to say yes to that PU, of course, unless he doesn't know, the essential elements, but I'm guessing he knows, then he'll have to ask the vendor that for me to issue this PU, you actually must give me this amount of money that is in your account. You have to now send it to my account automatically. And that is how, we deal with 5.11 without actually going through 5.11, because he won't be able to give you the PU unless, he has the money in his account. So just because of the PU, then you will be protected. He'll issue you the PU, even though 5.11 is not applying, the PU will protect you. That was my argument.
No, I'm getting the argument. No, okay, in as much as it makes sense, let's look at it practically from a practical view. You see, the money has already been deposited in the client's account. No, you're an advocate. The money has already been put in the client's account. You go on ahead and now start asking the client to transfer back the money to your account.
Well,
so that
you
now
can't
you
issue the PU.
Yes, and you cannot issue a PU unless you have.
Yeah, unless you have it. Yeah, unless you
now
have
let's
it.
look at the practicality of that step.
Yeah, so it's an issue of whether saying yes or no to the PU. But in the event that you agree to actually issue the PU, then you have to tell him to send the money to your account.
Yes. No, I'm saying the practicality of it. You're an advocate. Money is already in the client's account. The property is already paid you legal fees. And then you go on to the client and say, just put the money back into my account. Then there's just practicality aspect of it. Why isn't it that from the beginning, you just secure the transaction by telling them to deposit in the client's account, and it will be a stakeholder arrangement in that sense. Instead of it going, coming back, coming back. Yeah, you're getting.
Yeah, I get it.
But how many clients will agree to such a situation or such a proposal?
Yeah, I understand. But what if they have interest? They want to sell this property. They need the money. So long as they do it.
Yeah, I'm saying why should they go through the long route, that long route, instead of it being deposited in the client's account as a stakeholder in the first place?
Because the contract is said otherwise. And this guy needs security. You have to do what you have to do.
No, but the contracts, okay, now the contracts, normally how a sale agreement would look like, they wouldn't just outrightly, how can I put it, outrightly disapply condition 5. They will just say, the LSK conditions 2015 apply to the extent of its consistency with forth. That's one option. Or the other option is that this thing doesn't apply whatsoever in any circumstance. Yeah. So trying to look at a situation where, okay, it's plausible. I mean, it makes sense. But okay, just for the exam, just you can start with that, and then now you can finish off with the PU and try and explain it maybe as shortly as possible. Maybe that's how I'll go about it. Let's just start with the strong point of 5.1, because the person who was setting it was obviously looking at condition 5, the stakeholder arrangements or escrow accounts as such.
All right.
Yeah. Any other questions?
Yes, Solonka. Just a small clarification. In as much as we're explaining to Chris on how we are dealing with stakeholder accounts and how they operate and how the deposit is safe, can you also indicate maybe with the vendor's advocate that you would like that specific clause inserted in the sale agreement?
Yeah, that's
so that you have protection in as much as the LSK conditions apply. If you don't exclude them, you can also have that particular in your deposit clause. You can have that particular stakeholder, arrangement and explanation.
Exactly. At the deposit clause, that's the part where it has to go in the contract in writing. As you secure it, you have to put it there. Yes, that's totally true, and that's totally valid. That's fine, huh?
Yes, thank you.
Okay, now let's go on.
In regard to, sorry, I have a question in regards to this client's accounts.
Yes.
Do you open one account for all your clients, or do you open an account for every client that comes?
Okay, that's a good one. So okay, okay, legally speaking, it's prudent for you to have an individual account for every client. Yes, but practically speaking, that doesn't happen. Usually, they just have one account whereby everybody, like all the clients and all the monies for other clients, go through there. Yeah. So practically, you can't have, law firms have over thousands and thousands of clients. You can't have over 1,000 bank accounts. You just have one client account, and then you're good to go.
And so, if you put money in an account to gain interest, how do you decide this is how much that has been gained for Solonka's account, or this is how much has been gained for Pamela's account? How do you do that?
Oh, that's a very good question. I think it will happen with the books of accounts. So, you have, let's say, a client's account with Barclays Bank. And as much as you have that, as an advocate, you usually have your own books of accounts, those transactions that go in specifically and so forth. So, I think that's how you go about it. And then the interest usually doesn't even go back to the interest. Actually, in certain circumstances, interest will go to the client, but in most circumstances, advocates just eat that money. It's usually advocates' money to that. The interest that is usually given inside, that usually accrues inside. So the distinction is not there per se when you look at it from a practical point of view. But usually there's books of accounts for every individual deposit or maybe withdrawal and so forth that happens in a client's account. That's a very good observation. I'll actually go to the firm where I work and ask the accountant how they go about it. It's a very good question. I've never even thought about it, but yeah, thank you for that.
Saying the interest is going to the advocate, isn't that violating the advocate deposit rules, because it requires the interest in the client's account to go to the clients?
It's true. It does violate. I mean, legally speaking, I'm saying it should have gone to the client. It's just the way the government says they've done public participation, but in real sense, they haven't done any public participation. It's just some fictitious, or just some, shallow thing that they've done. It's the same thing that happens. Now, legally speaking, it has to go, but practically speaking, I'm not talking about where I work, but this is what even our professional lecturer told us back in class. Our interest in a kuaga 2% or key. They eat that. They usually take that. Planning.
I want to add on. Some questions you are answering. You are answering in practice and in
from a legal point or an exam point.
Yeah. So for us, we are going to do exam like there in professional ethics. So we want to say that kwa karatasi wamekuuliza what happens to that deposit. Then you say you see, you have to answer. So maybe also you just give us the viewpoint mostly of how it is done on paper. So unajua mtu unaweza sahau uandike hiyo wakili anakula.
No, you cannot say that I had exam paper. Okay, interest according to the, you will check the Advocates Act and the subsidiary legislation there under. That's how you any money that comes into the advocate's accounts, the client's account, they've provided for how they dealt with. Yeah, that's the procedure you will follow. Even legally speaking, if you want out there in practice, follow that good practice. It's good. It's prudent. But at the same time, when you're answering the exams, you use that approach. Yeah? So every client should have an account. That's the end goal. But you see, when you have a firm creating every individual client for every individual account for the clients, I don't know, maybe there are firms who do it. But I'll ask around and get to know about it. But I doubt they'll ever bring a question and tell you, do you open individual clients? Like, there's no way they will tailor that an exam question in such a manner. Is that fine up to them? Is behind time, behind. Go on.
When it comes to an advocate representing both parties, like in that case, it's advisable for you to open separate accounts and not mix them up. So in that instance, I think might be examined one of the parameters that have been set when you have the same clients in a transaction. Yeah.
That's true. That's true. That's true. I'm actually learning from you. That's true. So guys, do you go to number 3? Let's go to number 3 quickly and see if we can finish this paper. Number 3, what does it say? Somebody read quickly and then now we proceed to answer it.
Question 3. You have recently been engaged as a conveyancing counsel. On your 3rd day in the job, you receive via email the following memo from a senior partner who also heads the conveyancing department of your employer, Sharon Tugi LLP. She expects your response by email as well. So this is a memo from Mrs. SST to you, Pamela Annie Kanaidza.
The caption has been together with her mother out client for several years. Her mother, Daisy Kanaidza, as you may be aware, just recently passed on. In her written will, she bequeathed all her assets to her children, Pamela and Eric, equally. Pamela has decided to sell one of the properties, namely the farmland situated in Laikipia. The expansive farmland, popularly known as Karai Ranch, measures approximately 500 acres and is registered under the now repealed Government's Land Act, Cap 280. Pamela and Eric currently occupy a farmhouse within the ranch. Pamela has already secured a buyer, XY, and she also wants to buy a block of 8 apartments and will be moving into one of them. The titles to the apartment block, as well as Karai Ranch, are the subject of legal charges registered in favor of Exim Bank Limited. The title deeds are with the bank. Pamela has gladly instructed our firm to handle both transactions. Our probate department is dealing with the probate and winding up of Kanaidza's estate. I am off to Congo for a holiday later this evening and will not be able to honor a scheduled appointment with Pamela at 1600 hours. You have to stand in for me. A. Prepare a memorandum discussing the matters you will need to discuss and consider with Pamela and the action to be taken by you before drafting the sale agreement in respect of Karai Ranch. B. Draft a letter to the lawyer KYM Advocates for the buyer of Karai Ranch, enclosing a draft sale agreement and stating the relevant inquiries or information. Do not draft a sale agreement. Yes.
Okay, now let's answer this one quickly. What do you guys think? What are some of the issues arising here? What are some of the issues arising?
Transfer of charges. Transmission.
Okay, yeah, this transmission.
And subcharge.
Transmission. You mentioned what?
Issues of second charges.
We just talked about a second charge. Go on. What else?
Discharge of charge.
Discharge of charge. Just list them, then we'll go through each one individually and see and access the merits of each discharge. What else? Is there subdivision arising here?
I believe subdivision will fall under transmission as part and parcel of the process.
Okay, go on. What else?
Could we say transfer of charges?
Transfer of charges. We're exhausted, so that we go on to.
Can we also discuss with Pamela whether they intend to, whether she intends to buy out Eric from the farmhouse, as opposed to, okay, it will be discussed maybe under subdivision, because if Eric would be bought out, she can take his share and sell the whole thing.
Okay, that's fine. Okay. What else? What else will be arising over here? Okay, let's go on to consents. Do any issues on consent arise here? We just list and then we will look into the merits. Okay, but let's begin one by one. Let's start with transmission. Transmission, why?
Solanka, I believe transmissions, since the land is being passed from one person who I believe is the deceased to another by operation of that is by death. So in this case, I believe since transmission of death is divided into three, this one will definitely fall under
go on, please.
Of beneficiary from a proprietor to a beneficiary.
Okay.
So we'll have, I think, to check Rule 57 of the LRA section of the beneficiaries. So this process again will entail registering the transfer as well as I'm not certain. I think that's where that's what I can see.
Yeah, that's a good trial. Good trial. That's a great trial. So yeah, transmission is correct. So we are having property devolving by way of transmission. Somebody has died, and now the property has to devolve to the estate of the deceased person. So we have for transmissions, you need to note regulation 55 all the way to regulation 50. So for purposes of this question, 55 all the way to 57. But for purposes of revision, transmission, just take 55 all the way to 58, just fill the entire thing. So for transmission, basically we will have the property. So as transmission subject to confirmation of grant or probate. So 55 all the way to 57 gives the processes and procedures. Yeah. So the first transmission, what happens? Transfer happens goes to the personal representative. After it goes to the personal representative, and the personal representatives devolves it to who? To the beneficiary. Okay, that's 55, 56, 57. That's the process. So that's one issue of transmission. I'm rushing because I've already pointed the law, and it's pretty straightforward. If you read, you'll understand. It's really straightforward. The process is here. You just do a transfer by the personal representative to the beneficiary. How do you do it? For LRA 42, and it's supported by certain documentation. A grant of probate, certificate of title, and all this accompanying documentation. Okay, that's the first thing on transmission. Now, subdivision will arise whereby in the question they're saying the expansive farmland, popularly known as approximately 500 acres, and is registered as the GLA. So if she's stated or bequeathed in a will that the children will divide the properties equally, meaning they have to be the property has to be subdivided to 50 acres to 50 acres each. So there's an aspect of subdivision, yes. So subdivision, where do we get the provisions for subdivision? It's just the same need that I've given you. Legal notice number 278. Yeah, under legal notice number 278, the process of subdivision is found there. Start reading from regulation number 43. You need to read between subdivision, there's reparcellation, there's what else? There's partition. Actually, what's the difference between those things? What's the difference between partition and subdivision? What's the difference between subdivision and partition? The answer is on the screen, actually.
Subject to correction.
Mm-hmm.
I think subdivision should be more physical. One plot of land, then divide 2 or 3 or as many parcels as are wished. And in the case of partition, I think it's more notional, more interest. So if, for example, when I are joint owners, and I'd like my share and you yours, then what would follow is a partition as opposed to a subdivision, since we are adding our interests. Your interest from mine in the same plot of land. Yeah.
Okay, yes. Okay. You actually gotten it correct. So the difference between subdivision and partitioning is, in this circumstance, you're seeing the property has to be subdivided equally between Pamela and Eric. Pamela and Eric, you need to, you need to excise 250 acres for each to take equally. But there are circumstances where the title is held in common, meaning the title deed, let's say for instance, the title document is saying like Ipia, blah, 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 10 acres. Who are the proprietors? XX and BB. They are holding the land jointly as tenants in common. So severing that interest between the two is known as partitioning. That's partition. For subdivision, there is no joint tenants, there is no tenancy in common. It's just a matter whereby you want to excise some piece of land so as to do whatever you want to do with it. Maybe you want to sell it. Now in this circumstance, you're excising 250 acres for each to go to Pamela and Eric equally. So partitioning happens where there is a tenancy in common. So you're severing the interest. That's the difference between the two. So in this aspect, there's the aspect of subdivision, and in subdivision, you have, how can I put it? Sorry, you have regulation number 43. Read on regulation 43. That's the process for subdivision. The approvals by the county government, all these documentations that you need to lodge in the application for subdivision. It's as simple as that. When they ask you about the process for subdivision, just go on to regulation 43 because you're a lawyer. You're not answering the question from the perspective of a surveyor, where you have to give the details of, PP, this, or this, and this, and this. No. You're answering this question from the perspective of a lawyer and from the perspective of the law. So what's the law? The law is under regulation 43. And that's the steps for subdivision. So we've answered the issue on subdivision. Needs to happen. Now, somebody tell me, do we need the consent of the Land Control Board? What do you guys think? Do we need the consent of the Land Control Board in this transaction?
So look, I
You think?
That's needed because the farmhouse is basically an agricultural area. So the consent of the land board would be required so that there's no over-fragmentation of the land.
Yes, that's true. So you need the consent of the Land Control Board, and that stems from Section 6 of the Land Control Act. What does it provide? Each of the following transactions, that is to say, all these things, partitioning, whatever, subdivision, all those stuff, you need to obtain the consent of the Land Control Board. Okay, since you've been told it's an agricultural land, and being an agricultural land, that is, it's going to be, you need to mention that thing there. So the lecturer has to know that this person knows what they're talking about. Let me charge the laptop. Okay, the other thing is, we had listed them. The other thing is second charge. Whoever mentioned the issue to do with second charge, kindly tell me. How would it arise here?
Since the property is already charged, I think this one will fall under Section 57 of the LRA, which actually defines a second charge as a sub-charge. And so in this case, definitely the first is it the chargee will have to liaise with this other bank? Oh,
Is there another bank here? Which are the two banks? We have, okay, I'm seeing Exim Bank. Which is the other bank?
Oh, I think
is Pamela or Eric taking another loan from the question? Guys, are you seeing? Yes.
She wants to sell. She just wants to sell to
Yeah,
this
she wants to sell. Yeah. So since they just selling, there won't be any, because I don't think she's getting any banking facilities for any property. So if she was getting and the property already had another charge, and then now maybe they want subsequent facilities, what will happen is they will now get there will be a second charge or something, maybe if they want additional facilities. Okay, so here second charge wouldn't apply, but let's go on to the second one, which you guys talked about, discharge. So how will the discharge apply here?
I think discharge is one of two options available to the seller or the vendor here. She could choose to either discharge the property, then proceed to split, or she could choose the agreement of the prospective purchaser to transfer the land to them, subject to the charges, the subsisting charges, and so the purchaser would be taking over the charge. It would be taking over the loan. Yes, taking over the loan.
Yeah. That's a good one. Okay, now we'll come back to the issue of takeovers, loan takeovers. Okay, okay, that's good. That's good. So the discharge, there's a way in which you can structure this arrangement. She could discharge the property first. After discharging the property, then she can proceed to sell, or she can just take them or sell them with that discharge. Which I don't think any prudent seller will do such a thing, or a prudent buyer will do such a thing, will buy property that has not been discharged. Okay, maybe the aspect of, just for revision purposes, you have circumstances where you have an apartment. Yeah? The apartment has 20 houses. Now, for the building of those 20 houses, the developer had to take a loan. Okay, a loan of maybe, let's say, 500 million. Now, for 500 million, it means each and every unit in that property has an encumbrance, has a charge in it. What will happen there? What will you register when a new person comes and pays cash for that property? What will be registered is a partial discharge. Okay, that's all. This, for revision purposes, a partial discharge will arise there. So you have 20 apartments. The property, the development was financed by a bank. Let's say at 500 million. Now you're selling each apartment at maybe 30, 40 million. So if a new buyer comes in and buys an apartment, you register a partial discharge over that apartment, because part of the sum that has been obtained from buying that, from the sale of that unit will be used to go and discharge will be used to go and settle the bank facilities that are borrowed. That's just an example of how a partial discharge arises. Okay, now we have this thing, transfer of charge or loan takeovers. What is a loan takeover? Because it's a question that was asked in a conveyancing paper sometimes back. What is a loan takeover? Guys, what do you think a loan takeover is?
Oh, so
yeah, go on.
I think in this case, in this specific question, it could come in when for whatever reasons, although you have already told us, no prudent buyer would do that, would do the same. But if a buyer chooses to proceed with the purchase of the land, subject to the charges rate, then the chargee will have to also consider whether they want a new charger. So again, I'm venturing. So I think in that case, that will be loan takeover on the part of the charger. The charger will be changing from, say, if you're the one selling me the land, from you to me. So yeah, that would be, I've taken over your loan. Although I imagine that will also go to the purchase price. It will be minus, say whatever amounts are remaining on the loan. Yeah.
Yeah. Okay. Now let's start from here. Loan takeover. Who's taking over this loan? Is it the charger taking over or is it another bank?
The charger.
The borrower is taking over this loan.
Yes.
Another bank.
Who takes over another loan?
Another bank.
Yes. So the correct position is another bank. So what happens is
Another bank.
Yes. So you have person X. Person X has taken a charge with which bank? With Barclays Bank or Absa Bank. Then in between, person X is like, the interest rates I'm paying in Absa is so high. Let me, and I think Stanbic is offering lower interest rates. So what should I do? I want to transfer. I want to go to Absa instead of staying with Absa. I want to go to Stanbic instead of staying with Absa. That's how a loan takeover will happen. Meaning, Stanbic will come in and take over the loan of Absa Bank. That's a typical loan takeover. In the commercial sense, that's now a loan takeover. In the conveyancing sense, it's known as a transfer of a charge. Yeah. So that's how those transactions happen. So in commercial bit, we'll call it a loan takeover. In the conveyancing sense, it's called a transfer of charge, whereby the charge will be taken over by another chargee. So Absa Bank will come, they will pay let's say this person took a loan for 10 million with Absa Bank. What will happen is Stanbic Bank will come, they will pay the amount that is due to Absa Bank. And after they've paid, the loan will be transferred to who? To Stanbic Bank. Meaning now Stanbic Bank will become the new chargee. So that's how typically a loan takeover transaction happens. And in the conveyancing sense, a transfer of charge happens. Have you understood that one? Have you understood? Maybe do you need me to clarify some area?
Yes, we have.
Okay. Now in this circumstance, do we have a loan takeover or a transfer of charge happening?
I don't believe so, because the purchaser is only buying, is interested in buying the land. There's no maybe bank to do the same.
Yeah. So under that, we have only, I think, 4 issues that will arise. The issue of transmission, there's the issue of subdivision, there are consents, and also subdivision, and also aspect of discharge or charge. Is there anything else we've left out?
So long, I believe there's also an issue of sectional properties.
Okay. Go on, explain. Actually, to buy a block of 8 apartments. Actually, these are apartments. Yeah, sectional properties. Go on, explain.
Okay, that is all I have to say.
So this is where the partial, remember when I was explaining partial discharges, yes? Remember how I explained partial discharge? So when you buy an individual unit, it's partially discharged. You remember, you've gotten the concept of partial discharge and return?
Yes.
Yeah. So that's how it will arise. And then the issue of sectional property, it's divided into different, there are different units. Now, there's an aspect of units. What else? Shares. What else? Common property. What else? Management company. Actually, I had skipped that bit of 8 apartments. I don't know why, how I let Choka maybe. But yes, those are all the issues that will arise if you mention sectional properties. Units, each unit you get a single share, there's common property, there's a management company. What else? What else have we left out? So, you know, for each unit nowadays, under the new provisions on the sectional property, under the new Sectional Properties Act, each unit you get either certificate of title or a certificate of lease. I think you've sufficiently answered that question now. Is there anything you're thinking we've left out?
Yes, Solanka, just to add on the first part on transmission, I believe the issue of grant confirmation of grant or issues pertaining to letters of administration, it will have to be justified and as one of those documents that will be required in the registration of the transfer of transmission.
Yes, yes. Yeah. So yeah, I mean, those are the supporting documentation that you will use under regulation. We said from 55 all the way to 57, yes? The grants, you need the certified copies of grants of not administration, but probate. Because there's a way, yes. Yeah, and then the second bit is drafting a letter to lawyer KYM advocate for the buyer of Karai Ranch enclosing a draft sale agreement and stating the relevant inquiries or information. So this is just simple. I won't even do this question because it's pretty straightforward and simple. So what they want you to do here is just, it's legal writing here, drafting the letter. You need to have the refs, our ref, your refs, the date. You need to have the address for the advocates. You need to start up, you need to have a reference. You need to have, open up, then find and closed hearing, draft sale agreement for your what? For your perusal. So this time maybe they're negotiating for a perusal, comments, and further action or so forth. And then now you close it up. It's just a letter, 4 marks, and you're done with the question. So it's 11. It's 11, but I think we've covered much. We haven't managed to finish the paper, but we've covered a substantial bit of it. And we weren't restricted to the questions. We went on over and above to discuss everything with regards to the paper. So with regards to question 4, I haven't read it, but the redundant clauses when it comes to a lease, just the clause that talks about the terms and maybe the terms, the price and everything. Maybe we can do that one next time when we meet. Question 5 is on the differences between a lease and a license. We've done this before. 3 essentials of a lease: exclusive possession. What else? Definite time. What else? Exclusive possession, definite time. There's a third one. Somebody remind me.
Premises.
Defined premises. Case law for that is Street versus Mount Fodder, and read together with the Land Act. You can start from section 60s over there. 56, I think 56 going onwards talks about leases. And then advice, the 3, that's basically simple. Your client HSCB has instructed you to conduct a legal audit of its security documents. All the documents you have perused and deduced paper to be perfect, except for 2 where the execution does not appear to have been properly done. HSCB Bank now seeks your advice on what constitutes proper execution of security documents by corporates like the bank and also individuals, especially legal charges. So it's simple. How do banks execute documents? They are duly constituted attorneys of a bank, yes? They are duly constituted attorneys of a bank. If you can read this, just open it for you. From LRA 53, let me just open from LRA 53 for you to check the charge. Before we close up, we'll close in the next 5 minutes. So if you check from LRA 53, what's it written? It's here. So you can have either the director or say director stroke secretary. You can have the attorneys of the bank to execute this document. No, this is a charge. Oh, sorry, here it is. That's the borrower. I need the chargee. That's the charge. I need the chargee. Okay, it's not here, but in a typical. Oh, here it is. Here it is. Signed by the duly authorized attorneys of the chargee under and by virtue of the powers of attorney. This is how it's here. Sorry, I hadn't seen this bit. So by guys who have the powers of attorney, yeah, the duly constituted attorneys of the bank. That is how it's properly executed, together with the signature of a bank official as witness, or maybe the advocate for the chargee. Execute this. So that's how the chargee executes documents or charge documents. When it's a company, how do they execute documents? If it's a company, so for companies, you just follow the Companies Act. Under the Companies Act, if it's, I don't know if it's section 37 of the Companies Act. Let me just check. For companies, how do they execute documents, or how do they execute instruments? You'll start with section 37, yes, it's section 37 of the Companies Act. Either two authorized signatories or a director in the presence of a witness. You can just check. That's execution of documents by companies. Execution of documents by the bank, it's by the duly constituted attorneys of the bank. And then HSCB informs you that one of the borrowers who secure it, the process of realizing or selling the property. You just need to read section 90, go read section 90 read together with 96, and there's 93 also of the Land Act. I'm just pointing you to where the answers are. 93. Oh, that's the Companies Act, sorry. It's the Land Registration Act. Let's go to 90. So you have 90. Sorry, 90, 90, 91, 92, 93, 94. All those are remedies, but 96 is the one that's specific to the chargee's power of sale. So that's where the answers are, 90, 96. But read all those provisions together. And I think we can call that a night. So you can call that a night. So Mgarakisha, but I've just pointed you guys to where the law is, where you can get the answers from. Then if you have any questions, just call and then we'll interact. We'll interact further. That's fine, yes. Do you have any questions up to there? I even see it's past 11. Somebody muted me. Somebody can stop the recording, please.